letting law, the housing acts, case law, tenant-like-manner. What are these things and why do they matter so much to landlords and investors? Hello, I'm Ross, co-owner of Knights, the letting specialist. I've been a property professional for 20 years now. In these videos are for landlords, investors and tenants as we discuss all things residential letting related. So in this video we're going to be taking a look at some housing acts, case law, and we'll also be looking at tenant-like-manner, where this term came from and why it's important today. It's important for me just to preface this video and say that there are over 150 pieces of separate legislation that affect landlords in the current climate. So it's impossible to discuss them all, but these ones are core and central to letting property in today's market. We'll start with the Landlord and Tenant Act 1987. So this sets out the various rights and responsibilities of both landlords and tenants. Section 11 of the Act sets out who is responsible for repairing a property under the Act, and the term keep in repair is used as this requires landlords to keep up the standard of repair or put the property in repair if it is not in repair at the start of the tenancy. But interestingly, the Act does not impose a duty on the landlord to effect improvements to the property. And then we have the Housing Act 1988. Now this is the sort of overarching framework. This is the law that governs the private rental sector and those who operate within it. This sets out the statutory rights and legal responsibilities of both landlords and tenants, whilst the tenancy agreement sets out particulars of the agreement like the rent due or the period of the tenancy. The overarching framework of how the parties will act is set out in the Housing Act 1988. And then there is also case law. So by deciding a disputed point of law, a senior court can change or clarify the law, thereby setting a precedent which other courts are bound to follow in later cases. Now, this adds to the varying pieces of legislation that are already in existence, new pieces of case law are emerging all the time, which is why it's so important if you are a landlord or an investor to choose an agent that is A.R.L.A Property Mark qualified, so they're hardwired and plugged into all of these updates as they have. So a very important and quite prevalent piece of case law dates all the way back to 1954, and this was the case of Warren v Keane, 1953-1954, and Lord Denning presided over this case. And he made a ruling which still affects lots of tenancies today. So I'm just actually going to read word for word verbatim what Lord Denning said. He said, "The tenant must take proper care of the premises. He must, if he's going away for the winter, turn off the water and empty the boiler. He must clean the chimneys when necessary and also the windows. He must mend the electric light when it fuses. He must unstop the sink when it is blocked by his waste. In short, he must do the little jobs around the place which a reasonable tenant would do. In addition, he must not, of course, damage the house willfully or neglectfully. But apart from such things, if the house falls into disrepair through fair wear and tear or lapse of time for any reason not caused by him, the tenant is not liable to repair it." This means that under case law, the tenant is expected to carry out small jobs around the property themselves as part of everyday life. Cut the grass, change the light bulbs, unstop the waste pipes, clear the gutters, sweep the chimney, but that isn't cut and dry, so don't quote me on that, it depends on the property. Repressurise the boiler in the first instance, and just do some investigative work if things go wrong. All such items have been incorporated into our tenancy over time to protect our landlords and make the responsibility very clear. These things are crucial to understand in order to marshal an argument and defend yourself as a landlord and enforce the terms if required. With the current direction of travel of legislation, if you're thinking of managing a tenancy yourself because you know a plumber or an electrician, you probably want to think again, all things considered. It's very important to say that there's a lot more to a tenancy than just a contract and laws on a page. You've always got to consider the overall relationship with the tenant, and that's got to be at the forefront of the frame. Now I'd like to finish this video by just dispelling two quick myths that I come up against quite regularly from landlords, and I'm often explaining in detail to people to great surprise. So the first is, if you've given your tenant notice and you intend to enter the property and they don't want you to enter the property, you can still enter the property anyway. This isn't the case. So it's very important to understand this. A tenancy is a right to land under the law and must be respected as such. If you ask your tenant if you can set foot on the premises and they say no, you cannot set foot on the premises. If you set foot on the premises, you are liable for you're trespassing and harassing the tenant, and you'll be liable for prosecution under those laws. So it's very important you understand that, and you respect the law accordingly. No matter what it says in the contract, regardless of what it says in the contract, the overriding statutory law will prevail, because you cannot contract out of statutory law. And the second one is about professional tenancy cleaning. So we hear a lot that the landlord professionally cleaned the property before the tenancy commenced, and they are insisting that the tenant has a professional clean at the end of the tenancy, and the tenant must pay for it. And sometimes they'll even try and pick the firm that the tenant must use. This is, again, wrong. You cannot force your tenant to have a professional clean of the property. This breaches 5 separate pieces of legislation. What you can insist on as a landlord is that the property is cleaned to a professional standard, because there's nothing to say that the tenant couldn't clean it to a professional standard themselves. Our contract sets out this very, very clearly, and obviously the security deposit is held with the deposit protection service accordingly, but you cannot insist that your tenant has a professional clean. You can make deductions for if the property is handed back to you at the end of the tenancy in a dirty state and you've handed it to the tenant in a clean state, you can make deductions or propose deductions accordingly for that margin of difference, which we'll obviously oversee for our landlords. But I just wanted to run through those couple of things just to give you a little insight into how wildly complicated things can get, and how much you need the advice of a good letting agent. So that's it for this video. I hope you found it insightful and interesting, and thanks very much for watching.